Welcome to the Secure Your Creation podcast. I'm Craig Andrews, and this is the man of the hour, Mario Milano. I'm going to mess that up, I promise, but don't worry about it. I'll get it right one day. How are you doing, Mario?
Greg, thanks for having me on.
Yep. So it's started the new year, 2025, and there's a lot of things I'm assuming happening in the IP space. Would you agree?
Absolutely. Always a new development in the IP space.
Okay. So tell me a little bit about Mario Milano and why you created Milano IP. Tell me, why do you love intellectual property law?
Yeah. I've always been someone that likes to take things apart, see how they work. So that led me into the engineering field, particularly into the mechanical engineering field. And from there, seeing how these inventions are created and things like that, then I got to see how they're protected. What would prevent somebody from just copying somebody else's idea. And so then that led me down the path of learning about intellectual property, particularly patents and trademarks, and seeing how they work. And then from there, I said, "Oh, that seems like a pretty neat field. Let me look into that some more." And then, went to law school and became an intellectual property attorney.
Very
After
good.
I was an After I became an attorney, I worked for other law firms. I enjoyed that experience, but as I progressed in my career, started to look around and say, maybe there are some things that I would like to do differently from where I'm at right now. And
Mhm.
then I decided that, what better way to make my mark than to open up my own shop and offer high quality services under my own brand.
So I'm not a lawyer. Lawyer stuff confuses me a little bit, but you're going to explain it for me here. So when it comes to intellectual property, that's not just patents. There's more than just patents and intellectual property, correct?
Correct. Yeah. Intellectual property is the umbrella. And under that umbrella, there's usually four types of intellectual property that we talk about. And that is trade secrets, copyrights, trademarks, and patents.
So can you give me a breakdown of what each one of those are in a little bit more detail?
Sure, sure. So trade secrets are your secret sauce. One famous example of a trade secret is the recipe for Coca-Cola. There might be one or two people in the organization that know what exactly the recipe is, but they do take steps to make sure that nobody from outside of their organization would be able to find that recipe with a Google search or something like that. They keep it under lock and key. Uh, Copyrights are for artistic works that are in a fixed, tangible medium. So when you think about a copyright, that's for music, books, poems, movies, things like that. A trademark will protect your brand and your brand, any taglines that you might have. So, the Nike swoosh, that's a trademark. The Pepsi logo. I guess I'm kind of hungry, so I'm thinking about lunch and food objects. So that's what's going on right now. And then patents protect your inventions. They have d- design patents, which will protect the look and feel of your design or your object that you've invented. And then there's utility patents, which protect the way that something functions.
So in terms of a small to medium sized business or even the super large ones, how do they know which one they need, or which one do you particularly specialize in?
Yeah, so some clients that are experienced with it, they'll know what they're looking for. But a lot of my clients, they come to me and say, "Hey, I have this. How do I protect it?" Right? And so I'll walk them through that process, and I can help lay out the pros and cons of each. Because you could have a design patent trademark on the same object, and other times it's better to just keep it as a trade secret. And so, we walk through the steps of what aspect of it are you trying to protect? Do you want to protect just the design of it? Do you want to protect the way that your new invention works and how it operates? Then maybe the utility patent is the way to go.
Okay. So you offer basically like a consultation prior to the actual service of the actual patent, trademark, or trade secret service part of things. Would you say that's true?
Absolutely. Particularly, my practice focus is mostly on patents and some trademarks. And so it's a good idea for us to have that initial conversation, see if that's the type of protection that would really make sense for you, and make sure that your expectations are my services are in line with your expectations. Make sure that it's going to be worthwhile to actually go and get the intellectual property protection, and make sure that we are a good fit for each other.
So tell me about your background. I know when we had a conversation pre-production, you were referencing in terms of the engineering part of things. Tell me about some of the projects that you really love to put your hands on, the projects that you really love to delve in deep with for certain type of clients.
Yeah. So I've always been fascinated by like objects with moving parts, whether that's cars, construction equipment. I was a bricklayer for a while, so construction equipment is something that's near and dear to my heart. Uh, and so, yeah, anything that really moves is pretty neat, especially if it's accomplishing a task. Um, and if we can, from an automobile aspect, if we can make it go faster or stop faster, those are always fun projects to work on.
Stopping might be important in an automobile.
Yes, yes. And
So, go ahead.
yeah, hopefully you're thinking about stopping before you get to the top speed. It should be uh, ongoing consideration.
And then that would be a good opportunity to make sure that that patent is really yours, because if yours can stop better than
Yeah,
somebody else's, then they should be coming through you anyway, right?
yeah, yeah. And you would think that stopping a vehicle has been around for a long time, but they're constantly coming up with new ways to improve it, improving the system, improving the materials that you're using. Now with electric cars, you're going to have regenerative braking systems so that you're charging the battery while you're stopping. So always something new, even in older technologies.
Awesome. So tell me about, if you can, because again, I'm not a lawyer, but tell me kind of some of the new things coming along in the IP space that you might want to tell people that's coming down the pipe, if you know.
Yeah, so for 2025, fees did increase at the USPTO. It had been a little while since there was a fee increase, so that's something to consider. It's not a drastic one, I'd say it's in line with inflation, but if you're somebody who's filed a lot of patent applications, just want to check those update your prices so that you know what the new maintenance fees are, application fees, etc.
Hmm.
There's also they've changed the structure of the fees for continuations, which is where you file one patent application, and when you get a patent on that, then you file a second application based off of that first application. It's a technique that typically larger clients will use to make sure that they can prevent their competitors from copying their designs. But those fees are increasing, so that's another thing to consider.
So here I have a funny story for you, right? And I'm going to give a little bit about myself here. So you know how when you go to school and you had to take a language, and you go back and you go through class one, class two, and then you talk to the professor or you talk to the teacher and you go, this is all fine and good, but tell me some of the bad words, right? Tell me some of the bad words I
Yeah.
can learn in the language, right? So tell me some of the bad things that can happen in the IP space. Just, I don't know, whatever one that comes top of mind. The bad stuff that happens if you're not protecting your intellectual property in the proper way.
Yeah. So the number one thing that I see that people do that kind of get them into trouble, not even really trouble, but make it difficult to get to protect their stuff with IP, is public disclosure, particularly in the patent field. That's really not good. If you start telling people about your idea, or you start offering to sell your idea before you have your patent application filed, you can lose rights if you wait too long. In the US, there's a 1 year grace period. So if you told somebody about it today, January 8th, 2025, you would have up until January 8th, 2026 to actually file your patent application. But outside of the US, there are some countries that don't play that game. They just, if you disclosed it before you filed your patent application, you can't file, you're not going to get a patent. And
Mm.
there's not really any arguing around that. So, sometimes people are unaware of those rules, and so they offer, or they're talking about their idea in public somewhere. They forgot that they had to give a presentation on their new concept, so now they're up in front of a crowd and giving that kind of talk about their invention, and that can lead to a loss of rights.
Wow.
So yeah, it's a pretty big deal, because you spent all this time developing your idea. And then, you think you're going to protect it because now there's a lot of commercial interest in it. You're doing well, you're doing a lot of sales, and then come to find out, that you're not able to sell, or you're not able to get a patent on it. Can be pretty devastating.
So I'm assuming then, based on that, that you have a lot of people who might come to you after the fact. Is there anything that you can do for them after the fact, or is there a workaround? I know sometimes a workaround is the minimal option, but it's not the best option. But is there any type of workaround if you know that situation's happened?
Yeah. There is. We talk about, what was the disclosure, what it was included. Were there any features of your invention that you didn't talk about? Maybe we can get a patent on those features. What are some improvements that you have in the pipeline that, you didn't talk about before, or, you're still developing now? Those things we can still protect with the patent.
Okay, good. So there is hope out there for people.
Yes, yes. All is not lost, but just you should be considering whether you're going to be filing your patent applications before you start talking to other people about it. And most of the time, people are, right. It's natural that people think about, oh, what if somebody steals my idea? So they want to get protection first. But sometimes accidental disclosures happen as well.
Okay. So I remember when we talked before, you talk about that, and again, as a novice, I'm sitting there going, I want a patent on my brand, or I'm sorry, a trademark. I want a trademark on my brand, right? And I expect it to be done like in a week. Is that a real thing to be done super fast?
Like everything, haste makes waste. So if we can take our time, then that's usually better. Trademarks are usually filed a lot faster than patents. But for the trademark, unless you have a reason why you need to file right away, we would want to do a search first. Number one, to make sure you're not going to be infringing somebody else's trademark by adopting your new logo or trademark. And number two, it makes sure that we can make sure that we're going to that when we file the application, that we're actually going to be able to make it all the way through. That there's not going to be any issues, and we're going to be able to make sure that your trademark gets registered, rather than filing quickly without doing the search and then finding out, 6 months from now that we're not able to get the trademark for you.
And then how long is that process in a non-rest time? How long does that usually take?
Usually within a week or two, we can get the trademark application on file. We can do the search, review the results, have a discussion about the results, and then file the application.
Okay. And so the fees, something of the fees, do they generally change, or how does that work?
Uh, to do the search, we offer flat fee services to do the search and file the application. And for patents, we do offer some flat fee services depending on the technology. For a trademark, the flat fee is usually pretty consistent. Whether when we're doing the search or we're filing the application, regardless of what the underlying trademark is. For a patent, it really depends on the technology. If you have a bicycle, that's a relatively simple invention usually. Whereas, like a MRI machine or something very detailed kind of machine, then the fee would go up for that.
Okay. So some of the terms that I had researching was talking about patent portfolios. Can you give me a little bit on that? Because that'll probably be something we do in another episode, but just give me a brief idea of what that means.
Sure. So some people talk about the company-wide patent portfolio, and that would be all the patents that a company has, regardless of the number of products that they have. So, they might have a couple patents for product A, a couple patents for product B, and a couple patents for product C. We would say that the entire thing is the company's patent portfolio. And sometimes there's overlap, right? They might have one patent that they think is only for product A, but it might cover products A, B, and C in some scenarios. Other times we would talk about what is the patent portfolio for product A, and then we would look at all the company's patents and say, okay, all the patents that could apply to product A, that's the patent portfolio for that product. And the benefit of having multiple patents or an entire patent portfolio directed to one product is that when your competitors are looking, okay, product A is very successful commercially, we want to adopt a similar design, we want to sell a product like that. If a company sees that you have one patent, that might give them some pause. But if the company sees that you have 10 patents on that one product, they know that it's going to be very difficult to design around it. And so then either they'll just not release their products because they don't want to have to deal with it, or they'll come to you and ask you if they can take a license, which is where, a patent license is where somebody would pay you in order for you to give them permission to make that product and not assert your patent against them.
Mario, awesome, awesome, awesome interview. I think that when we talk about future episodes of the podcast, Secure Your Creation podcast, when we talk about future creation, we're going to really delve deep into all the different types of stuff, whether it be design patents, whether it be the schematics that you review, all that different detail we're going to do over different episodes. So what I would suggest is anyone looking for anything in the IP space, particularly patents, trademarks, trade secrets, and there was another one I'm missing. What is that?
Copyright.
Copyright. How can I forget copyright? Visit milanoip.com, and you can ask Mario and anybody in his staff in terms of help, in terms of getting your IP straight. I'm Craig Andrews, and this is Mario Milano, and we will talk to you guys next time.
Great.